Mr. Speaker, I'd let you take the podium if my committee would get in their seats. Okay, listen up. Y'all bow with me. Gracious Heavenly Father, again we come asking you to forgive us of our sins, to lead us and guide us, and not only what we do here, but in our personal lives. Let us do things that please you. Let us be ever mindful of the job we have here and how it affects each and every person in this state. Let us do good things. In Jesus' name we pray. Amen. Okay. Good morning. This is the Standing Rules Committee meeting. Rules is next. This is the committee side of this Rules Committee. And this morning we're going to be hearing from the author, and the questions will come from this committee. It's not a public hearing. I don't expect anybody to say anything unless they're on this committee. It gives me a great deal of pleasure to welcome for the first time in my tenure as at this job, the Speaker of the House, Mr. David Ralston. Mr. Ralston, you're on.
Well, thank you very much, Mr. Chairman. It's been a while since I've been to this committee. I had to stop when I got outside this morning. I asked a fellow on the street how to get here. And he told me. And then as I was walking away, he said, "But you really don't want to go up there." But I'm pleased to be here this morning, and I'm here, Mr. Chairman, members of the committee, on House Bills 142 and 143. Both bills are the result of a great deal of work, a lot of hard work, a lot of discussion that goes back over a period of many, many months. I have a lot of people that I'm grateful to for their help. The Majority Leader, Larry O'Neill, chaired a working group of House members beginning late last summer through the fall and leading up to the session that looked at this issue, looking at what other states were doing, looking at it in a very thoughtful and deliberative way. I'm very proud of the way that they approached it. And I'm grateful to the Majority Leader and all the members of that committee. Chairman Golick chaired the Rules Committee subcommittee that had a number of hearings, both at the subcommittee level and before this full committee, listening to member input and public input. So I'm deeply indebted to Chairman Golick for his leadership and work on the bill, as well as Chairman Wilkinson, the Ethics Committee Chair, who's here, who has been an invaluable ally on this issue and has worked on it extensively over a long period of time. When this discussion began quite some time ago here in the state, it was my determination that this House should approach this issue in a thoughtful and careful way. It's a complex issue. It's not an issue, as I've said before, and I don't say this to be critical, but it's not an issue that you can solve at a rally down in the rotunda. It's not an issue that you can solve with a soundbite. It's not an issue that you can solve in an op-ed piece because it's an issue that affects how elected public officials interact with those who represent all kinds of groups in our state, business groups, professional groups, industry, trade associations. You know, we talk a lot about lobbyists. You know, my mother told me that she wished I'd grown up to be something other than a lawyer and a politician, but she said it could be worse. I could have been a lobbyist. But the truth is that most Georgians are represented down here in the halls of this Capitol by a lobbyist, who represent their interest, and we interact with them. We are a citizen legislature. So the whole subject of how we interact has been the topic of a lot of discussion, and really kind of is the impetus behind both of these bills. The other component of the issue, in addition to sort of looking at that interaction, is what kind of message we as a House send to the people of Georgia about this issue. Because at the end of the day, our highest obligation is to those people who entrust these positions to us every 2 years. And so it's with those sort of principles in mind, or those two ideas in mind, that we have looked at this issue. The bills before you, I will kind of give you an overview of them, and I think Chairman Golick then will go through the technical aspects for those of you that have questions. But the components of the bills are fairly straightforward. That was another part of our goal, was to have a bill at the end of the day that no one had to wonder what it meant. No one had to wonder about how it would be interpreted or how it would be applied, but that it would be clear and it would be understandable and that it would make sense when people looked at it. So with that in mind, what the bills do is this. House Bill 142 basically provides a prohibition on spending by registered lobbyists on individual members of the General Assembly. That's a strong idea. I get that, and I know that's going to make for a change in the way things are done here in this House. My objective in making that proposal is twofold. One is, I believe that if we are serious about this issue, then this is the only solution, and moreover, I think it's the only solution that takes this issue off the table so that we don't have to come back here next year and fine-tune some limit, or the year after, or the year after, but that we're going to solve this issue now, and I think this is the best way to do that in the way that this bill is drafted. It does have some exceptions. Other ideas floating around the Capitol have those in them too. It has exceptions for events to which all members of the General Assembly are invited. It has exceptions for events to which all members of the caucus, both the Democratic caucus and the Republican caucus, are invited. We had a lot of discussion about other kinds of events. It also has a carve out because we heard from our colleges and universities who enjoy inviting all the members at least on one day a year to their campus for Legislative Day. The University of Georgia, Georgia Tech, Georgia Southern, I know do that. Other colleges may be doing that in the future. And so it allows for that. There's been discussion about other identifiable caucuses that have histories and traditions here in the House. The Legislative Black Caucus, the Rural Caucus, the Sportsman's Caucus, and others, and then local legislative delegations. I understand that an amendment may be offered jointly by Chairman Roberts and Chairman Smyrie that will deal with that. And I do not actively support, but nor do I oppose that amendment. I will defer to the judgment of this committee because I trust this committee and its wisdom on that issue. I frankly believe that those are legitimate events that we need to protect, as we need to protect the caucus events, and we have in the language of this bill. It makes makes some changes in our travel provisions. I know there's been some internal discussion about going to conferences, and which I found a little interesting because that's one of the few times a year that we get to interact with people other than registered lobbyists. But be that as it may, I know there's been some discussion about that. But you know, when we got to looking at the travel thing, we realized that not only would it affect like the annual trade meetings and annual conferences of many different groups of Georgians that want to have a chance to talk with us about their issues, but it would affect simply events that many groups have around the state every year. I know you all know that there are many groups that have meetings in the fall of the year leading up to the session on a regional basis. And so we wanted to keep an allowance for our members, all of our members, to be able to go if they so chose to those functions. And this bill will allow that. But it is a tough bill. It is a tough bill. I don't make any apology for that. You know, we're going to make a determination depending on the judgment of this committee and the judgment of the full House about what this kind of reform ought to look like. And I hope that this House will adopt this measure as being a reasonable measure that will truly allow us to go back home and look our constituents in the eye and say, we did the right thing. We did something that's clear and understandable. And we dealt with this issue in a way that will end the discussion. And so we can move forward and work on a few other issues that we have to work on around this building over the remainder of the session and in coming years. The other things that the bill does are there's been a lot of discussion about who is a lobbyist. That is a discussion that's gone on here for a few years now. And frankly, I have heard from people in the hall as well as members that there are a lot of people here on a regular and frequent basis advocating for or against legislative measures who are not registered. We have looked at how we kind of fix that problem. We've looked at what other states do, and I even resorted to Webster's dictionary one weekend to find out what a lobbyist was, and realized that Mr. Webster had a pretty clear definition. We've got people that advertise themselves as lobbyists who say they're really not lobbyists. So I'm not sure what the definition is in the minds of some. I was frankly a little surprised and a little disappointed, actually, that a lot of misinformation and misrepresentation and distortion got out there about our intention with the bill. The intention of this bill and the way it was written never was designed to capture people who want to come to this Capitol and talk as constituents with representatives and senators. That was absurd and it was ridiculous. The intention was never to capture people who want to come here and express their personal views on issues to members of this body or the Senate. But there are people here who hold themselves out as representing organizations who are here not on one issue, not on behalf of themselves, but on behalf of others, and they need to wear a badge. We got into a lot of hoopla about, making people pay for that privilege. Well, we did away with that. Everybody that's going to have a badge is going to get a break from that discussion because we lowered the registration fee from $300 to $25, which essentially will pay for the person taking the picture and making the badge and handing it over to you. And so people who want to represent that for something other than what it is are just plain not being truthful with the people of Georgia. But I think we have captured and clarified who needs to be registered and who needs to be wearing a badge, and that was one of our goals in this. Another important point is the commission that enforces and polices this law will have restored their rulemaking authority. I think that is a very, very significant part of this measure, and I think it's important that we do that. I don't think it's appropriate that we police ourselves. I think that lessens credibility in what we're doing, and so we're proposing that rulemaking authority be given back to the commission. In talking to the commission about their work and their mission, it became apparent, because there's a lot of discussion about their funding out there, that much of their work has been consumed of sort of a routine nature, not to do with people at the state level, but at the local level who may not even have opponents and are really not raising or spending very much money, if any. But a lot of their resources are being consumed with that kind of work. So we've made some revisions in who has to file with the commission, and that's, I think, in House Bill 143. I really believe the effect of that is to indirectly allow this commission to have effectively the resources that they need. And we'll certainly look at their funding needs as we go through the budget. One of the things that it's always amazing how things never get sort of told accurately, and I guess I shouldn't be surprised by that as much as I am anymore, but we gave the commission a raise in last year's budget, a raise over their funding, and it was a significant raise. We'll look at making sure they have the resources to do their work going forward, and I think by sort of letting them focus on what it is they ought to focus on will be very, very important. The final point that I want to mention is sort of a campaign finance piece, because we have been we have emphasized openness and transparency in our lobbyist spending laws and in our campaign finance laws here for a number of years in Georgia. We are proposing what I believe is an important change in the reporting of campaign contributions for the period from January 1 until the beginning of the legislative session. As many of you know, that has become a very active fundraising period. The reality is that in years off election years, such as this year, all that money that's raised by members of the General Assembly, the public won't know who gave how much until early July. We will have long been gone here from that at that time, and I think it's important that they have that information earlier, and we're proposing that we abolish the March 31 filing filing deadline, move it up to 5 business days after the beginning of session, so in the interest of openness and transparency. That's kind of an overview of the bill. I would appreciate the support of the committee. Chairman Golick's going to kind of go through any other technical issues that he wants to talk about. This is I understand the magnitude of the bill. I appreciate the support of members of both the majority caucus as well as the minority caucus. This is not a partisan issue. This is not an issue of the House against the Senate. This is an issue of how we as leaders respond to the public discussion, and we have laid out, I believe, the best and most appropriate response to that. And with that, Mr. Chairman, I will yield my time to Chairman Golick, if that meets with the permission of the chair.
It does. Mr. Golick.
Thank you, Mr. Chairman. I'll be very brief. Just for members of the committee, the substitute you have before you on House Bill 142, LC 256183S, beyond just structural and renumbering changes, there were very few, and actually really just one substantive change, and it was really more of a clarification, and that comes on the bottom of page 1 going into page 2, and this just clarifies that any rule, any reporting rule that the Commission had in effect as of January 1, 2013 carries forward and remains in effect for purposes of the effective date of this bill. It doesn't provide for any additional reporting requirements separate and beyond what the legislature would mandate as a policymaking body of the state. But if any reporting requirement was required by the Commission by rule or reg as of January 1 of this year, that's still in effect, and that still remains status quo going forward. You'll just see, just for clarification, in lines 29 and 30, the qualifier to the January 1 is so long as such rules and regulations do not conflict with this chapter. Well, there's no change in this bill that creates any conflict with this conflict with any reporting rule that the Commission required, as we're told by Legislative Counsel. So that's really it with regard to any substantive change. It's really more of a clarification. On House Bill 143, the amendment that you'll have, and this comes from Legislative Counsel, which is AM 251308. This is a technical amendment that Council caught to make sure that we're including school board members as it relates to local filing requirements. That's addressed in 143, and that's it. I'll have naturally our Chairman Roberts and/or Chairman Smyrer will speak to their amendment AM 251309 at the appropriate time, and that's all I have, Mr. Chairman.
Okay, you've heard the explanation. Is there questions of the Speaker or Mr. Golick? Ms. Abrams.
Thank you, Mr. Chairman. Thank you, Mr. Speaker. Actually, to Chairman Golick, there was a discussion in the subcommittee, and I briefly offered an amendment looking at line 310 for HB 142.
Did you say line 10?
Line 310.
Oh.
The concern that I raised in subcommittee is that by setting 5 calendar days, this doesn't really take into account the period that, you know, if you're here as a citizen lobbyist, if you're here for the 5 days to push a bill, and you have either success or failure on your position, it doesn't take into account the time that you then need to lobby the governor during the 40-day look-back period that he has, and it also doesn't take into account the potential of a special session. Can you speak to any contemplation of adding that language?
Sure, I understand what you're saying, but I go back to the provision that, look, if you're a citizen lobbying an individual, lobbying an individual member, the governor, whoever, as an individual, there's no limitation whatsoever. So I don't really see that as an issue. If you're lobbying as a citizen, there's no limitation whatsoever. So I don't know that. it ends up really being effectively an issue from a practical standpoint.
Well, I guess I'm questioning the selection of a 5-day window of sort of amnesty and how effective that can be given the actual structure of the way we operate our government, which is that we have this 40-day period for the General Assembly, a 40-day period for the look back for the governor, the potential of another special session, and then the rest of the legislative, or the rest of the year. I'm trying to figure out the utility of a 5-day amnesty period when it doesn't take into account the actual calendar that we operate under here.
Right. I mean, again, this is going. I hear you, but I just don't see how it's an issue with regard to an individual. I mean, we can have that conversation. I'm sure the author is open to a conversation going forward. I think, if anything, during the process, we've demonstrated that no one's looking to limit anything. We want to be realistic and reasonable from a common sense standpoint as to who needs to register, who doesn't need to register, without infringing on any First Amendment rights to petition one's government. However, if someone's here on behalf of an organization for more than a certain period of time, we offer 5 days as a possibility, then that individual's attempting on behalf of an organization to influence a public official. That's the very definition of lobbying. Therefore, they should register. It's not a closed conversation. I don't remember actually receiving any specific language personally, but that's not to say that language doesn't exist. That's an open question. There's no closed doors on that whatsoever. I mean, I'm speaking for myself. I'm not going to stand here and, hopefully I'm speaking for the author, but I have a feeling I am.
And I guess I am now. Madam Leader, I had to be convinced of the 5 days because the whole notion of quantifying this was troubling to me. You know, we're not asking people here to drink poison. We're asking them to wear a badge. That's all we're asking them to do. And you have to draw a line. So, you know, through a lot of discussions, they prevailed upon me that, you know, 5 days was a reasonable line to draw. I think it is. I mean, we can debate, you know, should it be 5? Should it be 10? Should it be 50? And you know, but what we're talking about is wearing a badge.
Thank you.
Mr. Peake.
Mr. Chairman. Mr. Speaker, Chairman Golick, I know you guys have tried to address every situation, make sure we cover every base. I'd like to offer a friendly suggestion, very friendly suggestion this morning on line 94 of HB 142. We've offered exception for a branch of, for an athletic event from a branch of the University of System of Georgia. And I know it's late in the game, and I apologize for bringing this morning.
No pun intended, though, right?
That's right, no, sir. I'm wearing my Mercer tie, but we do have private colleges and private universities that do have legislative days in our state, and I would like to offer a friendly amendment, if I can. Sorry I don't have it in writing, where we would add at the appropriate time, Chairman Meadows, if I can just give the language and you can tell me when the appropriate time would offer the amendment. Line 94, after the word Georgia, or private university or college in the state of Georgia. So we can cover our private universities that do have legislative days for all members of the General Assembly. Appropriate time, I'd like to offer that amendment. Very friendly amendment. Since we
Mr. Smyrie.
Mr. Chairman, Chairman Golick of the subcommittee, we kind of engaged, and the majority of whip was involved in this as it relates to the 501c3 and the nonprofits. Is that, I'm looking at the old bill, that was something that affected them as it relates to reporting. Is it in or out of this draft? I can't. Do you remember the 501? Is that
became an issue a little more complicated for another day.
That's glad to hear that. All right, thank you.
He waves. Mr. Willard.
Thank you. Chairman Gold, I commend the committee's work doing the rule making by the commission. I think sort of long overdue. The question I have is on that rulemaking, is there, has to do with certain other agency oversight in the sense that they have to submit what will be rules for a body or committee of the General Assembly to review. If there's any objection to it, raise that objection before it's implemented. I think we'll step it down to the hallway. Should have done that as a way of trying to correct some problems a few years back.
I know that was discussed, and I think if I'm understanding your question clearly, it's a rule comes in, it might go to a committee of jurisdiction, which could raise objection prior to the beginning of the next session, and if they didn't, in this case, it would be the Ethics Committee, that would enjoin the ability of the commission to go forward on that rule until the next legislative session.
The reason I raised that, I think the knee-jerk reaction was previously when there was rulemaking authority in the commission, some rules were implemented that were really going beyond what was maybe their ability to stand. And that's why rulemaking is going to take away.
Mr. Lindsay.
The rulemaking authority is subject to the Georgia Administrative Procedures Act. And the Georgia Administrative Procedures Act has within it the concerns that you have set forth in terms of procedures, where a rule has to go to be submitted to the committee, both committees, the House and Senate and the legislature. They do have the authority underneath existing law to object to the rule, proposed rule beforehand, and also to object it after the rule is put into place and stay it until the next legislative session if they desire to do so. That's already in existing law for all rules and regulations in Georgia law, except for, I believe, EPD.
Ms. Drenner.
Mr. Chairman, I want to.
Carla, excuse me, Ms. Drenner, talk a little louder.
Mr. Chairman, I would like to follow up with Representative Peake's question regarding adding a private university. Is a private university defined as, would that include for-profit universities as well? So is that a Mercer and a DeVry, or is that just a Mercer?
I think it'd be a broad application. I think we'd have to recognize it in a broader context. Private's private, unless we have a more narrow definition of of a specific type of private university, for lack of a better description.
Mr. Roberts.
Thank you, Mr. Chairman. You have the amendment. If you want me to, I'll explain it now and then offer it at the appropriate time. Everyone should have it on your desk, AM 251309, that the Dean of the House and myself have sponsored. The Speaker spoke to a while ago as he was talking about the piece of legislation that we have before us. All we're seeking to do with this amendment is to make sure that all of our caucuses are recognized here in the body. Most of you know we have a rural caucus, we have a legislative black caucus, there's a sportsman's caucus, and to make sure that those caucuses that we recognize are held to the same standards as the regular House and the majority and the minority caucuses.
You've heard Mr. Roberts' amendment. Is there a second to his amendment, Mr. Smyrie? Okay. All those in favor of that amendment signify by aye. Aye. Any opposed? Hearing none. You've heard from Mr. Peake for a friendly amendment. Ms. Abrams, you're on. Mr. Peak.
It'd be proper maybe to address some of the particular issues to say, I had suggested or private university or college in the state of Georgia to put or accredited private university or college in the state of Georgia. Would that satisfy some of the questions?
Do it again.
It would read or accredited private university or college in the state of Georgia.
Accredited by whom?
Mr. Setzler.
Does it make sense to have the gentleman craft an amendment deliberately and sort of thoughtfully that could be brought through this committee tomorrow morning or something and offered on the floor? I don't know if that's a more deliberate way to do it to make sure we cover both nonprofits and for-profits.
We're going to handle that this morning in one form or fashion. Ms. Abrams.
Thank you, Mr. Chairman. I would actually offer a friendly restatement that it would be a private college or university accredited in the state of Georgia. If you do it that way, you limit it to those who are accredited in the state of Georgia only. You cover private colleges and universities, but you don't create the situation where someone could I can create a college or university in probably about 3 weeks. You don't want to do something that has the potential of consuming the rule, and because it's limited to student athletic, we don't define what student athletic is, so that could technically be, a lacrosse team or a chess team. But if you make it limited to those who are accredited in the state of Georgia, we have an entire system that verifies and validates that those are legitimate organizations in the state, and so would offer that as sort of a friendly restatement of his amendment.
Mr. Goley.
Just as a follow-up to that, I mean, would we need then, just thinking out loud, to put in some direct roadmap language within that to accredited by whom, or does that necessarily?
That's a known term in our language because that's how we determine who gets access to the Hope Scholarship. We have within our code other places where we reference colleges and universities accredited in the state of Georgia, and we have an accreditation process.
But you have to reference that code section,
exactly.
though.
Well, I don't think you have to reference the code section because I think it's mentioned several times in our code. So it's also an accepted definition. I wouldn't necessarily, because once you start referencing, we have to cross-reference to other places possibly, but I do think it's sufficient if we limit it to that. There are other places in our code that define what being accredited in the state of Georgia for a college or university, because any college or university trying to qualify for the Hope Scholarship knows that there is a limit to who actually gets to have access to those dollars.
I think we do better. I mean, just speaking for myself, Mr. Chairman, I think we do better to define it as specifically as we can, really just to go ahead and fortify those private universities that Mr. Peak is trying to loop in. But
Mr. Chairman, I believe putting in the language or accredited, just adding accredited into the original amendment, I think that will take care of what we're looking for. So that would be the amendment that I would offer.
I'd certainly defer. Just want to play it safe.
Mr. Chanel.
Thank you, Mr. Chairman. The question is to Representative Goldick. Isn't it true that if Representative Peak's amendment is approved, then that would take care of colleges like Young Harris College and others?
Yes.
That's my impression.
Thank you.
All right. Mr. Lindsay.
Just one friendly suggestion. I don't see any reason for the word or. It should be private accredited colleges or universities.
All right, who's going to put that in the form of words? We can't hear you.
I'm on. I'm
There
ready.
you are.
After the word Georgia, or accredited private university and college in the state of Georgia.
Okay, after the word Georgia, or accredited private universities or colleges in the state of Georgia. Oh, let me go again. Private accredited.
Okay. I'm sorry. Or private accredited university or college in the state of Georgia.
Ms. Abrams, clarify me.
I just want to make sure we're saying private college or university accredited in the state of Georgia. Because if you just say it's an accredited college, you have universities that can be accredited somewhere else. They may operate here, but they can't qualify for certain things. So you want it to be accredited in the state of Georgia, which is what pulls it under our rules for accreditation.
Private university or college,
private
college accredited in the state of Georgia.
Yes, sir.
Okay, that's the language.
Yep.
All right. Mr. Weldon.
Thank you, Mr. Chairman. I would just like to suggest an amendment to the amendment. And if
Mr. Weldon, who are you sitting next to? That's judiciary. Let's don't get too carried away with all this getting in the ruts here.
Yes, Mr. Chairman. I think the purpose is to catch all colleges or universities accredited in the state. And if we struck the language on line 93 after the word of, and beginning with the word the University System of Georgia, and inserted language that says any college or university accredited in this state, then that would, I think that would catch them all.
I'm gonna go with the first one. Okay, we've got the amendment, and it's after Georgia, and it will be private university or colleges accredited in the state of Georgia. Although I need a motion for that. Second. All those in favor signify. All right. Now we're going to go back to the bill. LC 25618-3S as amended. I need a motion.
So moved.
All those in favor signify by aye.
Aye.
Any opposed? Okay, Mr. Speaker, 143.
May I just observe that after that discussion about private colleges and universities, I will not miss the first legislative day at Mercer. I'll be the first one there and the last one to leave, I promise you. I think I went through House Bill 143, Mr. Chairman, and I would ask for a due pass recommendation from this committee.
Okay. Wait a second. Wait a second. We have an amendment for 143. It's on your desk, AM 25-1308. Mr. Golick.
Mr. Chairman, as per the discussion earlier, this is a technical amendment on behalf of the author, as drawn by Legislative Council, as a technical correction to make sure that we collect in school board members as it relates to the local reporting requirements. That's all it does. I'd move the amendment.
Have a motion second. Any discussion on that amendment? Hearing none, all those in favor signify by aye.
Aye.
Any opposed? Okay. 2 HB 143 LS 256162S as amended. Do I hear a motion?
So moved.
Do I hear a second? All those in favor signify by aye.
Aye.
Thank you. Let me clarify something before we get to regular rules. As most of you know, I wanted to put this thing on the floor for tomorrow. However, because of the passing of Ms. Marietta Taylor, there's going to be a huge amount of our people from the Columbus area that aren't going to be able to be here tomorrow. This will be on Monday's calendar. We're not going to do it tomorrow. We're going to put it on Monday's calendar, and I'll go ahead and take a motion for that right now. All right. Mr. Speaker.
Thank you, Mr. Chairman and members of the committee. I've enjoyed my visit. I'll try to come back more often.
If you're going to take this much time, don't come back. Okay. The Standing Rules Committee is adjourned. We're now on the rules calendar. Let's go. Line them up. Okay. Everybody get. All right. Shut the door. To the wall. 12 minutes to 10. You're supposed to begin at 10. These people don't like staying in here and missing the preacher. Okay, I lied. These people don't like staying in here. You be quick. You be quick. Mr. Hightower.
Thank you, Mr. Chairman, members of the committee. I come before you again today bringing HB 175. As discussed yesterday, this deals with covenants and dealing with public policy that most of our case law out there states that covenants do run with the land, and we're codifying that public policy.
Any questions, Mr. Hightower? Thank you.
Thank you, Mr. Chairman.
Mr. Dickey.
Thank you, Mr. Chairman and members of the committee. I come before you just today for House Bill 298 that would create the Agricultural Commodity Commission for Georgia-grown products, a voluntary promotion funded that will not cost the state any money. I ask you for that.
Any questions? Thank you. Ms. Quick.
Thank you, Mr. Chairman. I come asking for your consideration with regard to House Bill 252 and 253. That's local legislation from Athens to codify Canon 7 of the Code of Judicial Conduct, which prohibits judges from most political activity normally associated with partisan races and partisan politics. In terms of the partisan aspects of this, however, it is supported by the minority party in Athens, which is the Republican Party, and was requested by our Democratic incumbent judges, both of them. Thank you.
Any questions? No questions. Next one. I'm sorry. Any questions on 252 or 253? No questions. Mr. Welch.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. Members of the committee, I ask for your favorable consideration of House Bill 179. This will clarify in the law that recoupment of prescriptive drug medications issued by a pharmacist and done with a clerical error in the file would not be allowed by the pharmacy management beneficiary.
Questions? Thank you. Mr. Coleman.
Thank you, Mr. Chairman. Members of the committee, I come bringing the first of two major pieces of legislation from the Education Study Finance Commission that have been meeting over the last 2 years, and this is the first one. It's eliminating a lot of the revising, eliminating a lot of the Title 20 language that we need to update. Things like the superintendent should be housed in the courthouse of the county where it is. We eliminate much of that language, and that's basically what it does. It's pretty thick, but it's a lot of it's just mostly language.
What number is it?
283, I'm sorry. House Bill 283, I'm sorry, Mr. Chairman. House Bill 283. You had me in such a hurry. I'm sorry. House Bill 283.
Any questions? Thank you. Mr. Atwood.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I ask you for your favorable consideration of House Bill 161, which is a modernization of the bailiff's oath. Yesterday, when I spoke to you about it, I emphasized removal of the antiquated language, but I did not emphasize the most important thing, and that is that it prohibits a bailiff from allowing electronic communication devices, these things, into jury rooms. And this is the bill, and it's an important bill because this is how we deal with errant bailiffs. They have to swear to this. And in very emotional trials and other things, we don't need people reading newspapers and doing the other things they shouldn't do without the permission of the judge. So I ask for your favorable consideration. Thank you, Mr. Chairman.
Questions? No questions. Thank you. Members? Mr. Golick.
Thank you, Mr. Chairman. Under modified structure rule, House Bill 70, this is a bill that this House considered and passed during the last term. It relates to our special needs scholarship. As you may recall, there is a one-year requirement for the student to be in the school system in order to get their IEP, their individual educational plan, developed so that they can go ahead and transition over to the scholarship. But there are some kids who are too medically fragile and they have special medical needs, which means that they cannot physically go to the school. This will allow the state school board on a case-by-case basis, just want to stress, on a case-by-case basis, to allow for a waiver of the one-year requirement so that kids can go ahead and get their IEP designed, take advantage of the special needs scholarship, but not have any kind of medical risk that would occur if they were to be in the general school environment.
Questions? Mr. Willard.
Thank you, Chairman. In your book is House Bill 242, which is a thick bill. Will take application of the juvenile code. It also includes numerous policy changes of how we're going to be treating juvenile youth before juvenile courts. It is a program package that is really a government proposal, and honored me with the ability to carry it. We've worked on this bill for 4 years, and I think it's a major change in the direction the state will take with how they
No questions. Mr. Weldon.
Thank you, Mr. Chairman. I would like to put House Bill 161, House Bill 298.
Any questions? Mr. Peak.
Mr. Chairman, I bring for you HB 266, which is the annual so boring and complex legislation no one understands it bill. It's the IRC update, matches Georgia State tax code, internal revenue code changes.
Any questions? Mr. Stevens.
Thank you, Mr. Chairman. House Bill 179, just a Good Friday short bill.
Any questions? Thank y'all. Okay. We're going to do this is the calendar for tomorrow, Friday. Everybody wants to go home a little early tomorrow, right? Let's just don't do nothing then. All right. Modified open. HB 83.
Move.
All in favor? No opposed. I'm going to stop right there. I'm going to stop right there for just a second. I have forgotten something, and I'm sure y'all will forgive me. And I don't care if you do or not. Just bear with me a second. Mr. Roberts, would you like to ask for HB 274 in the absence of my chairman? And for those of you who did not see the demonstration and the bird, you missed one. Okay. Modified open. Okay. 274 with all those moves there, and I wasn't ready for it. Okay. All right. Anybody opposed to that? Under modified open, HB 161. Any opposed? It's on. Under modified open, HB 312. Any opposed? All right, under modified structure, HB 179. Any opposed? It carries. That's it. Hello. Tomorrow's meeting, y'all listen up for just a second. Tomorrow's meeting will be 1 hour before whatever time we go into session. I don't know what time that's going to be.